All right. Good morning. Good morning. Good morning. It is Friday, April the 21st. It is 10 a.m. And as normal, I'm going to give my 2 minutes of spiel. I'm going to give this 2 minutes of being a spiel, and then fundamentally, everyone is more than welcome to join in as I ramble on about assignments. So, a couple of basic points. Firstly, our forum is private. Our videos are not. Anything that you say on these videos can and will be used against you in a court of law. I know it's kind of sounds like where it's going, but actually what it is, just be aware that anything you say is public. Secondly, we have a lot of really good speakers that are starting to line up. Next week, I just posted it, and I'll put it in the forum after this. David Feld is giving a perennial favorite on new build adjustments. David's joined us here today, but David is pretty much the expert on new builds. Anyone who knows anything about our industry and has dealt in the new build space knows that Feld Kalia is pretty much like one of the premier shops. His volumes and his knowledge of the new build space exceed really him and Sonia's knowledge really exceed probably in one finger what most lawyers have in their entire brain. And David has generously agreed to give his talk next week on exactly what those pesky adjustments are and how to read them and how to protect your clients. Following that, by the way, the next talk we have scheduled is going to be on privacy and copyright issues, which I'm really excited for. That's coming to us in June. Privacy, copyright issues, and the like, doing with open houses, dealing with MLS listings. It's a question that we get all the time. I'm very excited about that as well. As always, last point before 10:05 hits, invite your friends, invite your family. We don't care so long as they're professionals. Please, our forum is better as we have more and more professional voices who join us. So without further ado, let's turn our attention to our session today. And our session today is on assignments. And I always like to have a little thing at the very beginning. And because assignments is really one of the trickiest things that an agent deals with, I thought that the introduction should simply be, and then me saying, back. And then you realizing you can make good commission on this, me agreeing, and then us proceeding forward as we start looking at what an assignment is. So without further ado. A lot of what so I've given assignment talks before, but I always change my assignment talks because there are a lot of changes that happen in the assignment world. And there have been a lot of the changes that have taken place, particularly as regards to tax consequences recently. So this is a brand new talk using some old material, but actually updating them. So I'm going to quickly go through a couple of things. I'm going to assume that most of us do not understand assignments. This is different than the way I normally begin these types of discussions, where I make some assumptions that there's some base understanding of the OREA agreements and everything else. Most people who are approaching assignments, and even those people who have done it once or twice, are really quite unfamiliar with what the assignment is and the particularities of the assignment. I will assume you understand the OREA Form 100 and 101 for this. And as a result, what I'm going to be doing is I'm going to be building on what I think is your knowledge of how to use the Form 100 and 101 and apply it to the Form 145, 150, which is the assignment forms that we are familiar with. So the first thing to mention, and this is kind of a critical thing just as you go forward, is that assignments are permitted unless denied. I know. Realtor knowledge is that you must get third-party approval with the initial seller before an assignment can take place. And the reason that's drilled into our head is because part and parcel of every single new build contract in the world that we all sign is, in fact, there is a clause that says assignments are not permitted. You are contractually not permitted to do this. But the OREA agreement, Form 100 and 101, contains no such clause. And as a result, it is a basic truism of law that you can assign your contracts. And as a result, if you have a builder that's very junior and uses a Form 101 as an example, or if you're just dealing with a resale agreement, you are perfectly allowed to assign. As an example, last week, we had someone who could not close their deal. We found someone who was ready to assign their deal. And as a result, I worked out an assignment agreement with the assignee without even informing the seller of the fact that it was happening. The night before the deal took place, we finally consummated the agreement. And then I informed that seller that very morning of the transaction that an assignment had taken place and they were now dealing with this party. Perfectly permissible, because the terms of the agreement of purchase and sale are not that you will close in your name under the OREA agreement, not new build agreements, but OREA agreement, only that you will come up with cash and direct how you shall take title. So the obligations remain yours, to be sure. And if you fail to live up to them, even if you've assigned it to someone else, it doesn't relieve you of your obligations vis-a-vis the seller. But you can go ahead and assign your rights to someone else, and they can contractually agree to pay for your stated commitments. Perfectly acceptable. The reason we get builder permissions is because there is a clause contained in almost every new build agreement that says, contractually, I know you are allowed to assign, but you are promising me by contract that you shall not do it without my express permission. And that's the reason that realtors who deal regularly in assignments, and usually only do that for the new build space, believe that assignments require seller consent. So just pointing that out. I know that's not why you're here. I know you're not here to figure out how to assign resale agreements. You're just going to go to your lawyer in the normal course. You want to hear about new builds. But I just want to point it out because it's a common misperception and it's a good as place as any to start. Okay, let's move. I'm going to start by talking about the taxation of assignments. And the reason I'm going to start talking about the taxation of assignments is because this directly informs why people want to assign in the first place. So before I turn my attention to what's currently on the screen, I want to first talk about what was going on in our market until midway through last year. People were not needing to work. In fact, everyone who was working was a sucker. The assignment market, with a rising appreciation rate for real estate, and with the preferential tax treatment that assignments were being granted in practicality, if not legality, it meant that people didn't need to work. They just needed to put money down on an assignment, wait 4 years, and they would be able to make hundreds of thousands of dollars in many cases. More money than they would ever make at their day job paying $60,000 a year. And as a result, assignments became a boom. I know that this is a reality that most of you have lived, and so I'm speaking to the choir. You guys understand this, but I'm going to keep going through it because it's really important. It used to be the case that someone would go ahead and purchase 3, 4, 5 units at a time, knowing that as long as real estate appreciation continued to the moon, the value prop was just ridiculous. You would pay your taxes, and we'll talk about the taxes you used to have to pay, and you would come out with a lot of money. And as a result, when lawyers were speaking to their clients, I mean, personally, I would sit down with every single client and I would say, are you buying to assign? And every one of them would look at me deadpan, say, no, absolutely not. And, you know, if you just peeled back that onion a little bit, you would find out that they were lying. It's like, oh, really? Yeah. What job do you have? You're in the Ontario Civil Service. I see. And you're making $100,000 a year. And this is the 5th new build agreement that you're buying at $700,000. Thank you very much. You're clearly buying to assign. You're not going to end up here. But every person was adamant that they weren't, that was just their bat nut, their best alternative to a negotiated settlement. Having said that, most of them were buying to assign. And this became an industry. In fact, part of the heated demand for new builds that took place were because, in addition to the fact that people need a place to live, this just became a great way of making money. Let's examine why. So I'm going to turn my attention to this window here, the pre-rule change, and I'm going to discuss the way things were last year. And I'm going to contrast them with the post-rule change to show you exactly what the quantifiable difference are in the tax changes. So this here is coming straight from Schedule B. And by the way, these numbers are just made up, but I'm going to use these numbers throughout this presentation just so that we're clear as to what's going on. So under Schedule B, which we're going to go through together shortly, you'll see that basically there are 6 numbers that we care about. There's the total purchase price that's being paid for an assignment. There's the original purchase price that the assignor signed with the seller. There's the deposits that were paid under the original agreement, so from the seller to the builder. And then there is the payment by the assignee to the assignor for the assignment agreement, which happens to be the profit, the difference between 600 and 470, plus the return of the deposits, the $80,000. And then you subtract, of course, the deposits that are paid on acceptance, which you're familiar with. And then you get the balance of payment for the assignment agreement being $170,000. We're going to go into how these are paid, when they're paid, and everything else as part of this presentation. But for the purposes of tax, I just need you to start understanding these numbers as we start collectively discussing this. So if you think about what would have happened prior to the tax change of last year, the taxes payable by the assignor, by the seller. By the way, people always get mixed up between assignor and assignee. So an assignor is a seller, and assignee is the buyer. So when I say assignee, when I say assignor, what I'm saying is seller. So what would have happened before is, if you think about it, what's the profit on this? Well, the profit is the difference between what they had agreed to pay and what they got from the assignee. That is $130,000, right? So the capital gains on this would have been 600,000 minus 470. And because most people were paying capital gains on assignments, they would only pay 50% of that, which would be included in their income. Now, for those of you who are unfamiliar with tax, because all you do is throw this over at an accountant, when you take whatever your income is, you are then putting it up as against the graduated tax bracket. That is to say, if you only earn $10,000 in a given year, you pay nothing on that amount. After $17,000, you pay 22% of your total cumulative amount to the government. And after between 20,000 and 24,000, it's this amount, and so on and so forth. After 229,000, it's 54%. So for the purposes of simplicity, I'm just assuming that the assignors that are doing this are already in the top tax bracket, and thus they are paying 54% of whatever the income that comes to them to the government. Okay, just because I want to get through this without going into too much of a tax session. So the capital gain takes the $130,000, takes 50% of it, that being $65,000, and includes that in income. There was also, possibly at the time, HST that could have been paid at $27,300. Just a second. Previously, there would not have been. Okay, so I'm sorry. I really need to change this. This is not accurate. I should have gone through this a bit more carefully. So please ignore what's on the left-hand side. I'm going to speak to you as what happened. Previously, what would have happened is this was the only tax that was payable in most instances. In most instances. In addition, there was also, if the government determined that you bought your property with the intention to assign, then you would have to pay income tax on this amount, meaning that the full $130,000 would be taxed at 54%. And you would have to pay HST on the profit plus the return of the deposit. Okay, that's what previously was the case. That's legally previously what was the case. What actually happened was almost everyone got away with only paying capital gains on the deal. And as a result, if you were being taxed at the hardest marginal tax bracket, the only amount that you used to pay was $35,000. Please ignore what I wrote here. I'm sorry, I didn't look this over before I included this, and it's a bit wrong. I would have only paid tax of $35,100 despite having made a profit of $130,000. That's what normally would have happened. Yes, there was always the possibility of paying income tax on this, such that what you were paying was 54% of 130,000 plus HST of 130,000 and the return on deposit. There was that possibility, but that never usually came to fruition. Generally, what people were paying on assignments was simply this capital gain. Ignore what's here. I apologize for that confusion. Post change, it is a different story. Post tax change, the income tax is now at 100% because it's no longer a capital gain, it's now income tax, which means that 130,000 is now included in your income. And the government will be taking 13% on that profit as well. What does that mean? That means that whereas before the government was taking $35,100 on your $130,000 gain, now the government is taking $87,100 on your $130,000 gain, meaning that you are now netting $42,900, whereas before, and I'm just going to do out my math because it's wrong on the left-hand side, which is awfully confusing for everyone. I feel really badly about that. I'm sorry about that, guys. Just bear with me. Here, I'll just take out the calculator. Sorry. So whereas before someone was making 130,000 minus the 3510, whereas before someone was making $94,900 on this assignment, now they are making $42,900 on this assignment. That is a huge difference. And it substantially affects why it is that people are going into the assignment world in the first place. As David and Sonia will attest, the assignments that we now have crossing our desk are being done out of desperation, not profit. And what that means is that the people who are assigning are doing so because they have a position where they cannot close, not because they are going to become wealthier than God by having purchased. And that is a direct result of the post rule change for 2022. When I post these slides, which I will do on the forum, I will amend this particular section prior. Does that all make sense? Does everyone understand the change that took place? Yes? Anybody have any questions so far before I move on? Nope, we're good. Okay, fine. So let's turn our attention, if you don't mind, to the assignment agreement of purchase and sale, the standard 150. Now, those of you who are unfamiliar with the Form 150 will look at it and say, that looks pretty similar to the Form 100, to the Form 101. No issue. There we go. But those of you who watch it and see it a bit closer will see that there are actually substantive differences. The biggest and most consequential substance difference is the fact that there is no closing date. See, no closing date. And so I am going to turn my attention to how to actually interpret this contract and the things you need to understand when in fact we're going through it. The very first thing I turn my attention to in these contracts is the Schedule B. The Schedule B contains the payments that are to be made as part of an assignment agreement. And to be clear, you will hear from a million people about how the math is done on this session. Please don't listen to any of them. They are all wrong unless they say what it is I am about to tell you now. There is one way to fill out Schedule B, and I am sick to God of people filling it out incorrectly. In fact, it's the very first thing we do. Let's discuss. Line 1 is the actual assignment price. Line 2 is the original agreement of purchase and sale price. Line 3 is the deposits paid by the assignor to the builder. Line 4 is the payment by the assignee to the assignor for this assignment agreement, which we'll talk about. Line 5 is the deposit paid upon acceptance of the agreement. And line 6 is the balance. Where people get screwed up is not line 1, 2, or 3. They're always correct. Where people get screwed up is line 4 and line 6. And let's talk about it. The payment by the assignee to the assignor for this assignment agreement consists of two things. It consists of the profit and it consists of the return of deposit. I'm going to pause. It is a misperception by most who have not dealt with assignments, and rightly so. It makes sense logically. They think that when they get an assignment, that the builder is going to pay back the deposits of $80,000 that they have in their hand to the assignor and collect from the assignee, the buyer, that $80,000 again. But that's not what happens. And you have to understand this point in order to understand why people make this error. What actually happens is that the moment the builder says, yes, you, the assignee buyer, are the new owners of this contract, the credit that exists because the assignor had previously paid a deposit gets credited to the assignee. That's what happens. And as a result, because the assignee is getting a credit from the builder for the $80,000, they must pay back the $80,000 to the assignor because the assignor is giving them a credit of $80,000. Thus, they must pay back that $80,000 immediately to the assignor. And as a result, what is the payment by the assignee to the assignor? Not what's the profit, not what's the profit. What's the payment by the assignee to the assignor? It is the profit, meaning line 1 minus line 2, plus line 3. So the amount that actually has to go on line 4 is line 1 minus line 2 plus line 3. And once you get that, then you can figure out line 6, because all you're doing is subtracting line 5 from line 4. Pausing. Does everyone understand that? That is the most common mistake in assignment agreements. It screws everything up from the outset always. So does everyone understand how the math works on an assignment agreement? I'm pausing. If David or Sonia want to chirp in here as well, I know you guys deal with these things all the time. I can't see on my screen, but I'm sure you're sitting there agreeing with this. Anyone else want to say anything on this? No, we're good. Okay.
I just want to echo your comments about how this is the one and only way to fill out an assignment agreement, and there is absolutely no other way.
Yes, thank you. Thank you. All right. There is also something else contained in this agreement that people see fit to just totally ignore. I don't know why, but they do. And it is contained here between line 3 and line 4. But partially because people don't read standard form. They're like, it's standard form, but let's read through the standard form. What it says is that the deposit paid by the assignor to the seller, so we know it's $80,000, right? The deposit paid by the assignor, the original buyer, to the seller, the builder, under the original agreement of purchase and sale. And then it says something else. It doesn't just stop there. It doesn't say period. It says, is to be paid by the assignee to the assignor as follows. And so the next line, the line where you can select 1, 2, or 3, is part and parcel of part 3. What they're doing is they're saying, not only are we dictating how much has been paid to the builder, but when is it to be paid back by the assignee to the assignor? And there are 3 options: upon acceptance of this assignment of agreement and receipt of consent to assign from the original seller, upon occupancy, and upon final closing. Those are the 3 options that are available. We'll talk about which one you should select shortly. I'm just pointing out to you that there are 7 things you need to fill out on this form beyond the stuff up here. These 6 items and this. Does that all make sense? Okay, cool. Let's turn our attention to that tricky sent sheet of the seventh item was the actual amount that you have to put down on line 3. So you want to select one of the 3 things: upon acceptance of the assignment agreement, upon occupancy, or upon final closing. Tricky Schedule A. Let's do it. So salespeople are often confused on a couple of things when it comes to assignments. 1, when is the damn money payable? And 2, how do taxes work? And if I can answer those questions and take you through the clauses that we look for on an assignment agreement, and if you listen to this many, many times, ignoring that mathematical error that I had on that critical page, then you will understand how to do your assignments and you'll be able to present them to a lawyer who can fix them up with relative ease. So let's turn our attention to this. In the agreement, there are 3 places where an assignment money is called to be paid. There is, of course, the deposit, which you guys are all familiar with under the Form 100 and 101. It's the standard deposit upon acceptance. I'm not going to go into it. You understand how that works. And you know that it's paid to the brokerage. Then there's the return of deposits. We've talked about this. This is on Schedule B. When is the return of the deposit itself paid? So the $80,000 is what we're talking about in this scenario. And then there's the profit. And if you write nothing else in Schedule A, what it says that the assignee will deliver the balance of payment for this assignment agreement. So what's the balance if you select upon assign? So if you put $40,000 here, if you put $80,000 here, and you say that it's upon acceptance of this agreement and receipt of consent to assign, then the balance, which in this instance would be, so at this point, it would be $90,000, right? Because it's $210 in total. Let's go through this. 130 plus 80, 210 in total is owing. They've already paid 40. And if they've returned the deposits of 80, they've already returned 80. So 120 of the 210 has been paid. So $90,000 is now payable. That $90,000 would fall under this agreement here. It says the assignee will deliver the balance of payment for this assignment, subject to adjustments in the form of a bank draft prior to completing the transaction in the agreement of purchase and sale. Prior, because people don't like paying money out well prior, always means the same day as the final closing. So if you write nothing in the agreement and just fill it out properly, then what you've done is you have ensured that there's $40,000 paid on acceptance, $80,000 paid by the assignee to the assignor's lawyer at the time of builder acceptance, and $90,000 paid on final closing in conjunction with the balance still due to the other lawyer. That's what is if there's nothing in Schedule A and if you just fill out the form. Does that make sense? Pausing. Does that make sense? Because no one gets this. So I guarantee you, if you chirp up with a question, everyone else has that same question. No, we're cool. And look at us. Aren't we special? Okay, no problem. Can I repeat that, Lena? Yes, I absolutely can. So what I'm saying is that if you just use the default form and don't put anything in Schedule A, and you fill out that the deposit is paid, the original deposit, the $80,000 that was paid to the builder by the assignor, that it is paid back to the assignor on receipt of consent to assign. If you fill that out on line 3, then the standard agreement has $40,000 paid upon acceptance, $80,000 paid to the assignor's lawyer at the time of builder acceptance, which I'll explain. Maybe I should back up. So what happens is after you guys get your agreement signed between yourselves, the lawyer submits it to the builder and the builder circulates a 3-way agreement between the assignor, assignee, and itself saying, we accept this. When that document is signed, the $80,000 is then paid by the assignee to the assignor. And because $210,000 is owing under this agreement, and because $80,000 and $40,000 has thus been paid, then the balance of the payment, which is contained in Schedule A, this is a standard clause in Schedule A, is payable prior to final closing, the balance being $90,000. Does that make sense? Lena, are you good with that? Yes. Okay. Now, people who are good at assignments don't leave things to chance. And as a result, I insist and I look for clauses in Schedule A that specifically outline how the payment is to be made. And critically, from your perspective, these clauses are not equal. There are dangerous ways of structuring these clauses, and there are optimal ways of structuring these clauses. The best way, from a legal perspective, is option 1, which is exactly what we've described. And what I've done is I've said the payments contained in Schedule B are to be made in the following manner. And I just described it. Why? So that there's total clarity as to how this is going to take place. The deposit of $40,000 is to be paid to the assigner's brokerage and trust within 48 hours of acceptance of this offer. The deposits paid by the assigner to the seller under the original agreement, being $80,000, are to be paid to the assigner's solicitor and trust within 48 hours of receipt of the builder's permission to assign. And the balance of the contract, being $90,000, is to be paid on final closing with the builder. By writing that down, there is certainty as to when every payment is made. Why is this optimal? Why is there no risk? Well, there's no risk. In order to understand why there's no risk, we have to describe why there is risk, which I'll describe in a second. But let me start by explaining how all the monies that are paid in this manner are protected. The $40,000 is in a brokerage account, correct? Okay, no problem. It's protected by the brokerage. The $80,000 that's with the builder, that is going to be credited to the assignee. If the builder goes bust, if the builder says, I'm raising your price, if the builder does anything, that is carry-on guaranteed. It is amounts that they will give back to you if the agreement fails for some reason. So the assignee, in paying the $80,000, will definitely get back their $80,000 if the builder does some shenanigans or cancels the project or goes bust or whatever it may be. And because they're not paying the extra $90,000 until final closing, they're only paying that when they know that that closing is taking place anyways. So there's no risk. This is different than the option 2 and option 3 that we often see in the agreement. Let's talk about both of those. So option 2 isn't that risky. It really isn't. But all we're doing is we're saying, look, some people don't have cash. And so the $40,000 is to be paid to the assigner's brokerage, and the balance of the contract, being the $170,000 now, because they didn't return the 80, is to be given back to them. Now, the reason this isn't overly risky is because if you think about it, if the assignee fails to close, okay, the assigner is still able to step back into the shoes pursuant to the 3-way agreement that's signed and will close and has their $40,000 and can sue the assignee for failure to close. And the assignee, if they technically don't pay it, if they were, I've never heard of this ever happening, but if they were to just deal with the builder and only get the product and not provide the monies for whatever reason, well, they have an asset. You just immediately throw a caution on title and then you secure your payments. It's not going to be a case where someone ends up with $0. Conversely, option 3 is very risky. And I want to talk about this in some detail. When I was starting out my career, I tell this story quite often. I used to, about 80% of my client base was South Asian. I don't know why. Actually, I do know why. They told me why. I had no relationship to their community, and thus, when you air your dirty laundry, you want to air it with someone who you're not going to see at weddings. So I actually had quite a few South Asian people, and they constituted the bulk of my business for probably the first 10 years of my practice. Before I go into the story, sorry, Oliver asked the question. Just to be clear, the profit from the assignor is finally paid on. I'm going to answer your question with option 3, Oliver. Let me just preface it. Just hold on. So the reason I'm bringing this up is because originally I didn't just do real estate, I did corporate contracts and everything else. And I remember one of my South Asian contacts started introducing me to business deals. And South Asian business deals in Ontario always set my hair on fire. And the reason they set my hair on fire was because they would come to me and they would say, oh yes, we're going to make a deal for $500,000 and here's what the dead details are and everything else. And you'd say, okay, great, I'll get you the paperwork in like a couple of weeks and then we'll work it out who's their lawyer, yada, yada, yada. I'm like, all right, so we'll effect an escrow closing and you'll give me the money and I'll give it over to them. And then they would all invariably always stop and they'd say, oh, no. I've already paid the money. You're just papering the deal. And I would say, I'm Jewish. This is my background. Trust me, that's not the way things are done in my community. And so I would go, what are you talking about? You've given $500,000 to someone without a contract? And they said, oh, don't worry. This person's daughter married this person's son and I know them and we shook hands and they're good for it. And I kept on saying, like, can you please not do this? Don't do this. And then finally, one of my clients took me aside. He was actually a very interesting and very sage guy. And he said, Mark, you got to understand, in the old country, we have courts that don't work. It takes 20 years to see justice. And as a result, we do deals on handshakes because you can't rely on the justice system. He's like, and most of us are first generation, and we have a style of doing business that's congruent with our legal systems. Understand it, respect it, and let's deal. I said, you know what? That makes total sense. When I started dealing with the Asian communities for assignments, most of that is all cash. Most of it is all cash up front. It's a very cash-based society in China, and law is done in cash. And as a result, when you're dealing with first-generation Asian immigrants, there is a culture of actually paying cash up front. And actually, in Markham, most of the assignments deal with cash up front. That's just the way it goes. And as a result, we see option 3 continually happening, particularly in Markham, but never usually in Brampton. It's really interesting to see how the law is actually attenuated to the cultural communities that it serves. So option 3 is a risky way of doing this for an assignee. And what it says is the payments contained in Schedule B are to be made as follows. The deposit of $40,000 is paid on acceptance, and the balance of the contract, $170,000, is to be paid within 48 hours of receipt of permission, of builder's permission to build. I just dealt with a crying woman in my office. It was a terrible story, but she dealt with a really bad builder. And she did an assignment where she did not have a very good lawyer or a real estate agent. And they had agreed to pay the balance of the contract, the balance of the assignment, which was $150,000 up front. The builder failed to complete. And the builder, therefore, sorry, the builder didn't fail to complete. The builder is just terrible and ultimately has been asking for a lot more money to complete and said, look, you either pay this or sign a mutual release. But if she signs a mutual release, she'll get back her 80. I'm going to use these numbers that we're using here, just hypothetically, and apply them. She'll get back her $80,000 and her $40,000 is still in trust. No problem. But she has paid the extra 90. Who compensates her for the extra 90? Who compensates her? There's nothing in the agreement that says that in the event that the builder does this, that it shall be returned by the assignee. And even if there was, the assignee is currently in Iran. This is true. So there's no way she's going to get back her $90,000 because she released the profits before closing. So whilst you can probably get a better deal doing it this way, because you're saying I can pay all cash now, there is risk replete in that, because what you're doing is you're giving money to an assignor, which is not secured by Tarion, which is not secured by a lawyer's trust account, and which is not secured by a realtor's trust account. And in today's market, where things are starting to go sideways, this is not a problem where things always go up. But in today's market where things are going sideways, where builders are pulling projects, where people are terminating, it is not advisable to do so at all. There is risk. It is almost always the case that if you want to just be safe and easy, you select option 1 or 2. 2 comes with minimal risk. 3 is a risky venture. Your lawyer should be advising you of that. I'm not saying don't do it. Job of a lawyer is to say don't do it. But you sure as heck need to advise your clients as to the risk that can take place if you use option 3. I'm going to pause. Does everyone understand? And Oliver, did I answer your question on this? Yes? Good. Anyone else have any questions on this? We're just also astounded by the brilliance that has emerged from my mouth hole. We're not going to ask any questions here. All right, this mouth hole is going to continue. So when is the assignment money payable? Let's continue it. So we've talked about the yeah, thank you, Peter. All right, so the assignment money that is payable is negotiable, as you just saw. And one of the things that agents also like to include is when people can get their hands on money. And these for the assigner's benefit too, right? Merely saying that you shall pay $80,000 to the assigner or lawyer in trust, right? That's what we said. We said the deposits are to be paid by the assigner to the seller, are to be paid to the assigner, solicitor, and trust within 48 hours of receipt. That doesn't mean that you can conclude the deal, that you can go ahead and release the money. It just says that the assigner's lawyer is going to hold it. You need specific direction to allow the assigner's lawyer to release the money. Similarly for the payment of commissions. And so people put in all sorts of clauses, which we can discuss on a per thing basis, which basically say things like the parties agree that after acceptance of this agreement, I just made this up on the spot, any monies paid by the assigner to the assigner's brokerage or solicitor shall be immediately releasable to the assigner. The parties further agree that any commissions due and owing to the brokerages as payment for the services rendered can be paid and released at that time. This clause shall constitute the assignee's full and final irrevocable direction to release the monies in the aforementioned manner, and no further authorization is required. Right? Like something like that allows for the release of the money after it actually hits the brokerage trust accounts or anything else. And it allows for the payment of commission. Because when does an assignment close? And this brings me to my second biggest pet peeve of assignments. Please do not write the assignment shall close on the following day. It's ridiculous. Everyone who does assignments writes this shall be the closing date because they don't see it in the agreement, which is insane because in every instance where that's happened, there is always a payment that is set to take place after the closing date that has been selected. Now think about this. It's the agreement itself that is mandating the payment schedule that we've set out. If you were saying that the agreement has closed as of a given date, but there are still future payments to be rendered as between the assignor and assignee, on what basis do I have to say, pay me that money? The deal has closed. People don't think about this. And so there's this clause going around in good precedents too, by the way, which basically says this assignment shall close. Please don't ever use those words. It's just a pet peeve of mine. It makes no sense. No one's ever tackled it in court, but it just doesn't make sense. What they're trying to do is they're trying to say, hey, I want my commission, so I want it to close on this day. That's why they're writing that in. So write it. Just say my commissions are due on this time. Don't say the agreement is closed. Don't futz with the agreement. I'm going to pause on that one. Does everyone get that? Yes? Okay. Good. So you can keep an optional clause like this. Just please don't put in this shall close on whatever date, because it closes on the date of the final payment. Once all of the obligations have been made and met by both sides, the agreement ceases to exist. It merges. That's when a closing takes place. Even if there's no closing date, that's what happens. Okay. So let's talk taxes. Taxes. To understand taxation issues and assignments, unfortunately, you need to understand how new build condos work HST into a price. So let's talk. It is the case that builders like advertising lower prices than higher ones because that creates more demand. As a result, builders collectively all use a singular trick, which is to say, give you a price inclusive of HST, but exclusive of the HST rebate. That is to say, if in fact the purchase price on an APS is $565,000, what most people think that means, because they're told that it includes HST, is that the true purchase price is $500,000 and there's $65,000 worth of tax. That's what they think. Why wouldn't they? When they go in and they buy a chocolate bar from the drugstore and they pay $1, they are asked to pay $1.13. So if they are given a price of $1.13 and say this includes tax, they can work out that the chocolate bar is $1. And so that same math is what's in their head when they are approaching this and are informed by you guys and the builder that the purchase price includes HST. But that's not what the builder contracts say. What the builder contracts say is because you have stipulated that you will live there and because you will get your HST rebate and you have agreed to give it to us, now therefore the price shall be $565 inclusive of HST. What this means is that the true price, even though they write $565 on the agreement, is actually $589 because the builder is getting $565 from the purchaser and $24,000 from the government through the HST rebate. And so to figure out what the HST payable on this is, you have to actually take $565, add $24,000 and divide by 1.13. Does that make sense so far? I know that that's convoluted, but we deal with this type of stuff all the time. Hopefully that makes some sense. And by the way, the rebate's not always for $24,000. That's the crappy thing. The good news is this is not really that consequential because it is $24,000 above $450,000. It is. So almost every single assignment we're dealing with deals with the property that's more than $450,000. So it's not really an issue. But I'm just pointing out to you that the assignment, the HST rebate can go up to as high as $32,000. Actually, this chart is slightly off. It can go up to as high as $32,000, depending on if you're at a $550,000, $350,000 original purchase price. It's not always $24,000. It's only $24,000 above $450,000. But because that's most things, it doesn't matter if it's $2 million, $6 million purchase, it's always $24,000 above $450,000. And because that's the case for most instances, I'm just going to call it $24,000 as the HST rebate. So this HST rebate, the reason it matters for the purposes of assignment is that builders will, whether it's before occupancy, but definitely if the assignment takes place after occupancy, deny the HST rebate. And what that means is that the assignor, even if they're planning on living there, shall be paying an extra $24,000, which $24,000 they'll get back, but most people don't have $24,000. This is non-mortgage money, and they need to come up with it on closing. So the reason you need to understand the HST building rebate is because you need to be able to explain to your clients that this $24,000 is part of the purchase price of $565, was under the original assignor's contract going to be credited to the assignor, but will not be credited to the assignee. They'll still get it, but they have to pay it up front and claim it back. So they have to be prepared for that tax. And as a result, the clauses that deal with taxes in Schedule A, I decided not to write out the clauses. I decided to just describe them. Paulina, yes, Paulina's asking, can I explain how I got to 521? So why did I get to 521? Well, Paulina, take out a calculator for a second. So we're saying that on the agreement of purchase and sale, there was a purchase price of 565. That's what it says on the agreement. Okay. If you add, take out a calculator, I'm going to do it with you. So if we do 565, and then we add $24,000, because that's the HST rebate that the builder is getting, right? The builder is receiving 565 plus $24,000. So the true purchase price is what? Paulina, tell me. Sorry. Gali, please tell me. Sorry, I apologize.
589.
589. Now let's net out the HST because that's the true purchase price. So divide that by 1.13.
Okay, gotcha.
Okay, and that's the cost. And by the way, you only pay land transfer tax if you were purchasing this without an assignment. You only pay land transfer tax on the net amount, just FYI. So what you should be doing when your land transfer tax calculations on a new build, not an assignment, but on the new build, if you actually want to tell people what their true land transfer tax is, you take their purchase price, you add 24,000, you divide by 1.13, and you put that into Rate Hub's land transfer tax calculator.
Gotcha. Thank you.
Okay, no problem. Okay. So the normal clauses that you see as part of a assignee and assignor Schedule A is that the assignor is responsible for HST on the profit, because that's the new law. We've already talked about that, right? They're responsible for HST on the profit. They are responsible for income tax on the profit. It's no longer capital gains. They're responsible for the cost of receiving builder consent, and they're responsible for their own assignment fees. I will discuss my own fees and how I charge for assignments. I charge a lot for assignments. I'm just going to be very blunt about it. I hold my head up very high about this. Look, there are people who screw up assignments, and when they screw up assignments, it costs a lot. The amount that I charge on an assignment when acting for an assignor is my normal sale price, which is $1,450 plus $1,000. I charge $2,450 for an assignment where I'm acting for an assignor. Just FYI, just to set your expectations as to what a good lawyer should do, because you're going to get a bunch of people who tell you that they'll do it for $1,000. Good luck to you, unless they really understand assignments. I mean, maybe there is someone who's doing it for $1,000 who really understands assignments, but trust me, there is value that is created by taking this to lawyers who understand this type of stuff. You can ask David and Sonia, they deal with assignments every single day. Second, on a normal assignee, it's the HST rebate plus land transfer tax on the assignment price, not on the original price, on the assignment price. That's what they have to pay. All adjustments under the original agreement of purchase and sale and assignee lawyer fees, and to set expectations as to what my assignee lawyer prices are. Because I want you to know how much this costs. This is not the same thing. This is not like the cheapo closings. I charge $1,000 over and above my purchase price fees, which are on my website. I'm not here to advertise myself. But I'm trying to set your expectations as to where lawyers should be on this, who know their stuff. To deal with an assignment agreement over and above everything else, I charge $1,000 above my normal fees because there is a lot of work involved. So just prepare yourself for that. Anyways, these are the clauses that normally make their way into Schedule A. And this is my time to ask if there's any questions while I subtly keep my contact details on the screen for reasons that only the best marketers could possibly understand. What questions do you have for me? So can I do a post on the webinar with sample clauses of Schedule A? Yes, I can. Jack, maybe I'll do a follow-up to this with Schedule A clauses for sure. Okay. What else? Who else has questions? So Peter asks, so how does income tax work now that capital gains has changed? Capital gains hasn't changed. All that's happening is the government says that they're going to treat this as income tax, meaning that whatever the profit is going to be taxed at 54%, plus you're going to have to pay an additional 13% of HST. So if you're in the highest tax bracket, what that means, if you want a quick back of the envelope calculation, is that 66% of all assignment profits are going to be paid to the government in tax.
If I can step in for just a second, for the realtors that don't understand why this has happened, yet they heard rumors that CREA did a study, I think it was 1.5 years ago, where the government said that they were going to tax principal residences. That wasn't true. What CREA did was created a study where they showed the government where all tax was available. And then the government realized that if they increase the taxes to 100% as a business tax on assignments, they can leave the principal residence alone. So for your clients that are complaining about this, just remind them that our government, with the assistance of the CREA report, is not touching the home, the family home.
Interesting. I didn't realize that. Huh. All right. Camille asks, what's the proper way to avoid the most amount of taxes if you want to sell a pre-construction property you purchased? Camille, with respect, there may be ways to do things, but that is really the purview of an individualized question and really should be consulted with a tax lawyer or an accountant, not a conveyance lawyer. Remember, guys, conveyance lawyers convey. Very few of us understand taxes in detail. Very few of us are here for planning purposes. That's not to say we're not authorized to do it, but those people who take it on sure as heck better know what they're talking about. I would strongly suggest you get a tax lawyer or an accountant on that question if you are in that position, Camille. Okay. What other questions, guys? We have 4 more minutes. 4 more. I'm going to turn this off because I'd like to see everyone's face. We have 4 more beautiful, beautiful minutes. All right. Who wants to ask? Come on, guys. The mouth hole still needs exercise.
Mark, I'm just wondering if you can repeat again the land transfer tax, the calculation, if you don't mind, please.
Sure. Well, I'm not going to go just very quickly. The way the calculation works is on a graduated basis as well. So from 0 to 55,000, it's 0.05%. And then from 55,000 to 250, it's 1%. And I could go into it, but who cares? There's calculators online. What I was getting at is that on an assignment, you pay land transfer tax on the assignment price, not on the original price. Okay. Now, technically, although very few people do this, you don't actually need to pay it on the assignment price. You need to pay it on the assignment price minus the HST that is already built into the actual agreement, because you're only supposed to pay it on the net. So what you're supposed to do is you're technically supposed to take the net price payable to the builder and add the profit portion. And that's the only amount that you actually are supposed to pay on your assignment. I mean, people don't do that. People just put it on the assignment price, but there it is.
Mark, we'll go through this next week too, when we do the new build numbers.
Awesome. And they, frankly, they're the guys to ask, not me. I did. These guys do new builds like in their sleep. So that's great. Join us next week, Oliver, and you're gonna hear from the experts on that. What else, guys? 2 more minutes for Melcole. Nope. All right. So with that, we're going to wrap it up. Guys, next, can you talk the reason why an assignee ends up paying HST rebate even if they are moving in? Yes, I can. Camille, the reason that the HST rebate is paid by the buyer is because the CRA goes after the builder if there is a mistake, and builders don't want that liability. So what the builder is doing is saying, I don't want to be submitting anything on behalf of someone because there may very well be someone here who is lying. And what might they be lying about? Well, the law is that the assignee, excuse me, has to be the first occupier of the property. And if something takes place, particularly after interim occupancy, it is possible that someone else has occupied the property before the assignee. The builder cannot be sure of that. And if the CRA discovers that, will come after the builder for the rebate that they have qualified for. And as a result, they said, to hell with all this. You just apply for it separately. Any assignments as a matter of basic precaution. All assignments, we are denying the HST rebate, and you'll claim it and you'll show it over to the government yourself. Now, Gally asks the question that means that she is donating $100 to the Daily Bread Food Bank. Gally, I know you're new. I know you just joined this morning, but unfortunately, anyone who asks if there's going to be a recording, P.S., there's always a recording and it's always submitted on our site, has to donate $100 to the Daily Bread Food Bank. They appreciate your willingness to contribute and help out your fellow citizen. All right. I'm aware. Is there going to be 2 people? Svetlana. Wow, we make $200 for the Daily Bread Food Bank. Look at that. All right, good stuff. And if I'm an investor, not an end user, but rent for 1 year, yes, then you have to actually pay the HST rebate, and then you will get back what's called the HST rental rebate, which is for the same amount of money. David and Sonia will both talk about that. David and Sonia actually have a business in actually assisting people in getting back the HST rebates. So they will speak to that in detail next week on Thursday at 10 o'clock. All right. Is there any due diligence on Project Builder Tarion timelines that you would suggest before reviewing a potentially dated APS and entering into assignment? Ryan, with permission, just because we're hitting the end, I'm leaving that for David's talk next week. He'll talk about the due diligence of Tarion guidelines and everything else. All right, guys, it has been a pleasure as always. Wishing you all the best, and we'll see you next week.